Silence. All stand and remain standing until the conclusion of the reading of the proclamation. Ladies and gentlemen, the proclamation. All persons having any business before this honourable court now draw nigh, give your attendance, and you shall be heard. God save the Queen.
Ceremony for the admission of legal practitioners.
I would like to warmly welcome you to the second virtual admissions ceremony at the Supreme Court of New South Wales to celebrate your admission as a lawyer of this honourable court today. As we gather for this celebration, physically dispersed, I would like to recognise at first the various traditional lands on which we meet. This ceremony is being streamed from the land of the Gadigal people of the Eora Nation, and I acknowledge and pay my respects to the elders, past, present and emerging. My role as President of the Court of Appeal is to preside on civil appeals in the Supreme Court and to deputise for the Chief Justice when he's unable to sit. The Chief Justice regrets that he's not able to sit today, but has asked me to pass on his congratulations and good wishes to you all. This ceremony is being live streamed from the Banco Court. The Banco Court is used for all ceremonial sittings such as today's, as well as for any other matter in which the Chief Justice is presiding. Present with me on the socially distanced bench today is Justice Hoban to my right, who is the Chief Judge of the Common Law Division of the Court. To my left is Justice Davies, who is a Judge of the Common Law Division. Behind me, directly behind me, is Justice Stevenson, who is a Judge of the Equity Division. To his right is Justice Kuntz, who is also a Judge of the Equity Division. And to Justice Stevenson's left is Justice Irace, who is a Judge of the Common Law Division. Judges in the Common Law Division of the Court hear serious criminal cases such as murder and terrorism offences and also sit on the Court of Criminal Appeal. They also deal with administrative law, personal injury, professional negligence and defamation matters. Judges in the Equity Division of the Court hear commercial cases, corporations cases, probate and family law matters, real property and trust disputes, and exercise the Court's parens patriae jurisdiction. In these unprecedented times, you have all completed your admission formalities remotely. You swore an oath or made an affirmation that you will truly and honestly conduct yourself in the practice of a lawyer of the Supreme Court of New South Wales, and that you will faithfully serve as such in the administration of the laws and usages of this state according to the best of your knowledge, skills and ability. They are solemn obligations. Today, your admission was recorded on the Supreme Court's roll of lawyers. Today is a day for great celebration and pride. It is a day which marks the culmination of your legal studies to date, when you can look back with pride and no doubt relief on endless caffeine-fuelled nights spent trying to memorise carefully tabbed and annotated case summaries with the aid of an entire rainbow of highlighters, the many hours of lectures spent analysing eggshell skulls, snails and ginger beer bottles, whilst trying to figure out who your neighbour was, and just when you thought your student days were over, a few more months squeezing in PLT assessments. There can be no doubt that you've all worked incredibly hard to get here, particularly in the trying circumstances of the last 6 or 7 months. And on behalf of the Court, I congratulate you all and warmly welcome you to the legal profession. For many of you, and whilst for not for one moment underestimating your own hard work, energy and dedication, your achievements would not have been possible without the significant support of your family and friends, who've no doubt stood by and encouraged you through the seemingly endless years of study, and have also no doubt been on the receiving end of your finely honed skills of argument and persuasion, even if in recent times this has occurred virtually. Many of those supporters, I hope, are joining in this celebration this morning with you to honour and mark the occasion. In participating in the ceremony today, you, the newly admitted lawyers, have become part of a tradition which dates back to the 12th century, when it first became common for those representing others before courts to swear an oath before being allowed to practice. The first admission ceremony in this court was held almost 200 years ago in 1824, and it took place just a few blocks away physically from where the court building is, on the site of the David Jones Women's Department. Testament to the enduring nature of these ceremonies, young lawyers like you were admitted even during the midst of the Spanish flu and during the World Wars. Today's formal ceremony recognises the commitments you have each made to uphold the rule of law, to administer the law competently and with honesty and integrity, as have centuries of lawyers before you. It is out of respect for this long and proud history that we mark your admission with today's formalities, which also reflect and recognise the institutional continuity of the Supreme Court of New South Wales. That continuity is symbolically reflected in the fact that the judges on the bench are wearing the same robes and wigs that have been worn throughout this court's history. Despite this time-honoured tradition, the virtual nature of this ceremony is of course far from traditional. This is only the second time that the Supreme Court has welcomed a new cohort of lawyers into the profession by a ceremony such as this. Thus, you are participating in what is on the one hand an ancient, yet on the other hand an undoubtedly modern ceremony. Of course, I and the judges appreciate that this is perhaps not quite the admission day that you would have imagined, but that should not diminish for one moment the significance of your achievement. This virtual ceremony reflects the agility and dedication of the profession you are entering to deliver justice outside a bricks and mortar courtroom. Throughout history, our profession has proved itself adept at change, and never more so than in the last 6 months. We transitioned to a virtual system of justice at previously unimaginable speed, and since mid-March, the New South Wales Court of Appeal and the Court of Criminal Appeal have together heard more than 400 appeals, with counsel and solicitors and occasionally judges sitting remotely. And although jury trials have been interrupted for obvious reasons, judge-alone criminal trials and civil trials have continued largely uninterrupted. As you may be experiencing right now, dining tables have become the new bar tables, family dogs the new courtroom security, and interrupting children the new rowdy members of the public and the gallery. This transformation was only possible due to the commitment of the profession to ensuring that the wheels of justice continued to turn. This is something for which we should all be immensely proud. Of course, this is not the only change that has occurred in the legal profession. For almost 100 years after the first admission ceremony was held in New South Wales, women were not allowed to be admitted into the profession. In 1902, Ada Evans became the first woman to obtain a law degree in Australia, but she was never able to practice because of unjust laws excluding women from public life. She campaigned tirelessly, the laws were changed, and Murray Biles later became the first woman admitted as a solicitor in this state just over 100 years ago in 1918. She was told she would only ever be a typist. Instead, she ended up with her own practice at Eastwood. And when my distinguished predecessor as President of the Court of Appeal, the Honourable Margaret Beasley, ACQC, was first admitted to the bar in 1975, at a time when there were separate admissions of barristers and solicitors, she was only the 37th woman to be admitted in the history of the New South Wales Bar, which had by then existed for 150 years. Happily, we have come a long way since that time. Today, more than half of the solicitors with a practising certificate in New South Wales are women. 2/3 of the Council of the New South Wales Bar Association are female barristers. Many of the most senior positions in the law are held by women, including the Chief Justice of the High Court, the Chief Justices of Victoria, Queensland and the ACT, and the Chief Judge in Equity in this state, Justice Ward. Justice Beasley is, of course, now the Governor of New South Wales, and the profession is more diverse than ever before, and this is something which we should and do celebrate. Of course, there is still a way to go in improving both gender and cultural diversity in the profession, particularly at senior levels. Systemic barriers and prejudices continue to hinder some from fully and equally participating in the legal profession. This must change, but both the Law Society and the New South Wales Bar Association are agents for change. Our profession is only as strong as it is diverse. Community confidence in the administration of justice is enhanced when the people practising, applying and enforcing the law are representative of and empathetic to the wider community. An inclusive profession also strengthens access to justice by providing culturally and gender-sensitive services. No one, irrespective of their gender, sexual orientation, ethnicity, religion, disability or socio-economic background, should be left out or left behind from pursuing a career in law. There is also an important and increasing recognition that more must be done to ensure that all lawyers have a safe workplace, free from sexual harassment, discrimination and bullying. The normalisation of working from home, which has arisen over the past 6 months, will make, I think, the profession more family-friendly after the pandemic passes, and recent changes to the Legal Services Award will better protect the well-being of graduate lawyers. Another important feature of the modern legal profession is the greater awareness of and sensitivity to mental health and well-being, particularly topical with yesterday being National Are You OK Day. Even aside from the pandemic, there will be times in your career when you may be struggling at work and you feel disheartened or overwhelmed. Looking after your mental health is not something to be ashamed of. You should take the time, when needed, to seek professional help and to turn to the enduring things in your life, like your family, partners or friends. Both the Law Society of New South Wales and the New South Wales Bar Association have some excellent resources on looking after your health and well-being, which I encourage you to be aware of and to explore. Now, an important part of this occasion is to remind you all that in joining this profession, you have agreed to uphold particular ethical rules and values. You are not only joining a profession, but one of a particular kind. The role of lawyers as officers of the court means you are subjected to a body of ethical rules that is different from and more demanding than those that are imposed on ordinary members of society. We make no apology for that. Trust, honesty and integrity are cardinal requirements in this profession. Where those qualities are absent, as regrettably they sometimes are, those practitioners are called out and stripped of the status that has been conferred on you today. That status is a privilege, not a right. This is always important to remember. At a time when mistrust in many institutions is rife and there has been an erosion of respect for them, it is your duty, and indeed it is in your own interests, to foster and preserve public confidence in the legal profession. It is, after all, to the legal profession that citizens look when their liberty or well-being, be it personal or financial, is at stake. Respect for the courts and those who practice in them is at the bedrock of a civilised society. This sentiment runs particularly true in these current unprecedented times. You're all becoming lawyers in a time like no other, as is obvious. Our world is reeling from the turmoil of global pandemic, which has generated fear and uncertainty, destroyed livelihoods and curtailed movements across suburb states and countries. Despite the crisis, the rule of law has not been suspended, and now, as an officer of the court, which you have become, you are a trustee of the rule of law. When I use that phrase, I'm referring to the idea that everyone is both bound by the law and entitled to the benefit of the law. It requires the fair and consistent application of laws by institutions of integrity, and in which legal practitioners participate at all times with honesty and integrity. History has taught us that human rights are at their most vulnerable in times of crisis, and it is to the courts that citizens look to uphold the rule of law. As a profession, we must be vigilant in protecting the rights and dignity of those disproportionately affected by emergency measures. But we must ensure that the most vulnerable have access to quality legal representation and to the full benefit of the law at all times, not only in times of the current crisis. Many of you would have chosen to study law because you wanted to promote human rights, to reform policy, or to advocate for the most vulnerable in society. Never forget why you decided to study law in the first place. Irrespective of whether you practice in a commercial firm, a community legal centre, or pursue a career outside the law altogether, I encourage you to use your legal knowledge and capacity for critical thinking and service for the public good. Those of you who do go into practice must also uphold a duty of competence. You now have the privilege of conducting yourself as a lawyer because you are proven you are capable of understanding our complex system of law. But the knowledge you gained at law school is worthless unless you retain it, strengthen it, and increase it. In this profession, the learning never stops. By continuing to update your knowledge, you'll be in the best position to serve your clients, and the wider legal system will benefit. Courage and moral fortitude are other qualities which you should aim to bring to your work as a lawyer. You do no one a service, least of all your clients, by telling them simply what they want to hear. At a personal level, be aware and warned that some setbacks and disappointments inevitably lie ahead. But fortunately, the collegiality far outweighs competitiveness in the legal profession, and you have today joined a profession whose support will prove invaluable. Although it's understandably easy to feel isolated whilst we as a profession continue to work predominantly from home, remember that even when you are working from home, you are not working alone. And when normality returns, as I hope it will soon, throw yourself into your work and your new profession. Finally, try and strike a balance in everything you do. The best and wisest lawyers are those who are well balanced. And, my own personal credo, never forget to have fun and don't take life too seriously. The law is a marvellous, important and rewarding career on so many levels. Embrace and enjoy it. And so, on behalf of the Chief Justice and all of the judges of the Supreme Court of New South Wales, I once again congratulate you on your admission and formally welcome you to the legal profession. The court will now adjourn.
Silence, all stand. This honourable court is now adjourned. God save the Queen.